Lower courts must consider themselves bound by higher courts' ruling and decisions.
Hey guys, welcome back to the Final Takeaway audio podcast. We appreciate you stopping by and checking out our content. Before we begin, please note that as of yesterday, viewers can comment on our videos only if they are subscribed to the channel. So don't be shy, just hit the subscribe button and let's get acquainted. Now, let me tell you that pressure is mounting on the magistrate that's hearing the Mohameds' extradition case. Pressure to rule in favor of handing the men over to the United States Department of Justice for them to face charges in a Florida federal court. And yes, we're talking about Magistrate Judy Latchman. Now, of course, no one has come out and expressly ordered Latchman to commit the men for extradition. That would be considered judicial interference, right? Say, for example, by the executive branch of the government that's paving the way for the Mohameds to be sent to the U.S. Instead, one can use a different strategy. One only has to drop subtle hints, if you know what I mean. They only have to insinuate or imply what needs to be done at the magistrate's court. So, why are we saying that the magistrate is under pressure to rule in favor of extradition? Well, it stems from what Guyana's Attorney General Anil Nandlall said recently while he was updating the nation on the extradition proceedings for Azruddin Mohamed and his father Nazar Mohamed. Don't worry, you'll get to hear directly from Nandlall during and after which I'm going to provide commentary and pose questions to encourage meaningful dialogue on this topic in the comment section. So don't leave without jumping into the comment section and letting me know what you think. But getting back to Nandlall, he says he's of the opinion that the magistrate has two options to choose from when it comes to this extradition case. The first one is to grant the order of extradition, or the second option is to deny the state's request to extradite the Mohameds. Let's hear directly from the Attorney General.
The magistrate can uphold their submissions and refer the questions to the High Court for determination. Or the magistrate can dismiss their application and rule, as she is empowered to do under the Constitution, that the questions raised are frivolous and vexatious, in which case the magistrate is then required to proceed to embark upon the committal hearing now, to make the committal order to extradite. What all the magistrate is required to do is to say that there is sufficient evidence to extradite and to make the order for extradition, or don't make the order.
Wait a minute, am I tripping? Or was the AG about to say that the magistrate is entitled to rule in favor of the government, meaning rule in favor for extradition? Frivolous and vexatious. All that means is wasting the court's time with petty and unfounded claims that were either decided in past cases or cannot stand up in court. Show of hands if you think it would help greatly if the AG explains things in simple everyday language to help more people to understand. Anyway, let me put it in the context. If the magistrate believes that the arguments that are being made by the attorneys for the Mohameds are legally valid and that to order extradition could create injustice, she has the power to refer the case to the High Court for a judge to hear further arguments. Now, Nandlall almost had a slip of the tongue for good reasons. Earlier on, he said that the magistrate is bound by law or entitled by law to follow the decision of previous extradition cases. He claims that questions similar to those being raised by the attorneys at law for the Mohameds, for example, about the legality and constitutionality of extraditing the men, were already answered and decided on by previous courts. Basically, the men's lawyers are saying that it would be unlawful and unconstitutional to extradite the Mohameds to the U.S. based on the current laws in Guyana, and based on the contents of the extradition treaty. But let's hear again from Nandlall.
We have rulings coming from higher courts, which rulings are binding on the magistrate. You know, we operate under what is called the doctrine of precedent. And in the doctrine of precedent, there is a principle of stare decisis. And that principle says that the decisions of a higher court are binding on a lower court. So the magistrate, being a lower court, cannot depart from those very clear and conclusive determination of those very issues that are being canvassed now by superior courts. More so, our Court of Appeal, which at the time was our highest court in Guyana. That is long before the CCJ came.
Therefore, according to the AG, based on what is called the principle of stare decisis in law, the magistrate has a legal duty to follow the decision of those cases that were decided by higher courts. Those previous decisions are called precedents that set up how these types of cases should be decided in the future. So great, there are previous cases for the magistrate in Mohameds' case to follow. However, I'm asking Nandlall this. Should a magistrate, for example, Magistrate Judy Latchman, follow the decision of other magistrates and or judges out of duty or out of what's right and just for the defendants in each particular case in accordance with the law? Which one is it? Is it a either or it depends on? The next question is, has the learned Attorney General considered that each case turns on its own facts and circumstances, and therefore there are times when the decision of the court may go against a previous decision or precedent, as they call it in law? By saying all of what he said, it feels as if a subtle message is being sent to the magistracy to rule or decide on the extradition hearing in a certain way. Some individuals may even interpret some of the AG's statements as attempts at judicial interference, which could impact a free and fair hearing for the Mohameds. And they have a constitutional right to due process and a free and fair hearing. Magistrates and judges are supposed to function independently, and it is believed that Magistrate Latchman is capable of making a decision that is not only just, but also in alignment with what the law expects of her, based on the unique facts and circumstances of the Mohameds' extradition case. But moving on, AG Nandlall also makes it clear that the ultimate power lies in the hands of the Minister of Home Affairs, whoever that person is at the time. That minister and only that minister could finalize, certify, and concretize the extradition of Azruddin Mohamed and Nazar Mohamed. Here is a trivia question. How many of you knew that? So yes, the court does not have that power.